How are you? So is your mic on? Oh, thank you so much.
Must it be on red? Good morning, Deputy Chief Justice. I'm fine, thank you. How are you?
I'm fine, thanks.
And good morning, Commissioners. I'm sure all of you are happy that it's Friday.
Right. You have applied for a vacancy in the KZN division.
Yes, DCJ.
And not for the first time, am I wrong?
That's correct.
Is this your second time here?
It's my second time.
All right. You are an alumnus of the former University of Durban, Westville.
Yes, DCJ.
Where you obtained a BA and an LLB.
Yes.
Right. So after you got your LLB, according to your CV, you went straight to the sidebar to do your articles.
Yes, that is so, DCJ.
And you started practicing as an attorney.
Yes.
To date.
Well, there has been a break in my private practice. I served articles as soon as I completed my degrees, and then I started a private practice, which I ran until 1996. I then sold that practice and joined the Industrial Court bench, where I was from 1995 to the year 2000. I then joined the CCMA as a commissioner, arbitrator, and that's where I am currently.
All right.
During 2015, my two children, who are also attorneys, started a private practice, and I joined them there as a partner. But as I indicated on the last occasion during my interview, that I haven't been litigating, haven't been a litigating lawyer in that time.
All right. What kind of work does your practice do?
It specializes in labor law, but in the time between the last interview and this interview, I've taken the time to acquaint myself with the work that is done in our office, and it's civil litigation and commercial work relating to FIDIC, for example, commercial leases, and insurance litigation.
All right. You have acted as a judge in the KZN division intermittently since 2017.
That is so, DCJ.
And you acted at the labor courts as well.
As well, yes.
Between 2021 and last year?
I beg your pardon, DCJ?
Was that between 2021 and last year?
It was in the latter half of 2021.
Just that half, the 2 terms?
I did 10 weeks at the labor court, out of which 1 week was pro bono, yes, at the second half of 2021.
All right, and what is the total period of time you've spent at the High Court?
I think it would be about 60 weeks, if I'm not mistaken, or just maybe...
60?
Might be 50 weeks.
Sorry?
I think it's 50 weeks, DCJ, and then I add...
50 or 15?
50.
Oh, okay, 50.
Yeah, plus 10 weeks in the labor court, which would make it 60.
All right.
I believe that might be the approximate number of weeks.
Okay. Did you sit in both the civil and criminal courts in the High Court?
Yes, I did, DCJ.
All right. In all the courts, you went through the whole gamut, agent court, motions.
Yes, I've done
appeals.
the whole spectrum of cases in Pietermaritzburg as well as Durban, motion court, civil trials, criminal trials, reviews, appeals, civil appeals, and criminal appeals, as well as full bench and full court appeals. I always get confused about that, which is full bench and full court, but 2 judges and 3 judges, also where I have scribed the full bench judgments as well in civil court, civil appeals.
All right. Your application indicates that you have no experience in constitutional law, constitutional and administrative law. Now, if you've gone through the whole spectrum of cases. How could you have avoided coming across constitutional and administrative law issues?
I've not practiced, but I understood you to, the questionnaire to ask about my litigating in constitutional law.
In your practice?
Yes, but as an acting judge, I have come across constitutional principles, and I've had to deal with cases where I've had to consider pacta sunt servanda, the rights of children to education, etc.
All right. You don't have any reserved judgments according to your application form?
Not at the moment.
But you did list 2 trials, 1 criminal and 1 civil, that was still pending?
No, they're all completed, these.
They've been finalized?
Yes.
All right. Did you manage to write any judgments during your acting stints in both the High Court and the Labour Court?
Yes, DCJ. In the High Court, I've written about 40 judgments. In the Labour Court, I wrote 30 judgments over that 10-week period. That's
30?
30 in the 10-week period. That's apart from the urgents and the extemporaries.
Yeah, that's quite an output.
In a 10-week period.
Any of them taken on appeal?
There is one currently pending appeal in the High Court. I understand the judgment should be handed down soon. There were a few leaves to appeal in the Labour Court. I don't know what the status of those appeals would be. But in the CCMA, I've written hundreds of awards, and I've not been set aside at any point. In fact, some of my awards have been upheld by the Labour Court and the Labour Appeal Court.
Mm-hmm. You would be aware of the concern raised by AFT, the Advocates for Transformation in KZN, who say you are better suited for the Labour Court, and they complain that you struggle in the High Court. They specify your experience in the motion court, which they say you are not able to manage, you get overwhelmed, they say. And they also complain that your turnaround time to deliver judgments is poor, and that parties have had to wait for extended periods of time for judgments from you. Would you like to comment on?
Perhaps I'll address the last one first, DCJ. I understand that they say that there was a leave to appeal that some time was taken to deal with that or to hand down a judgment there. I've had very few applications for leave to appeal, and I've not delayed any of them. On the contrary, in crime, I received 2 applications for leave to appeal, and I did extempore judgments there. In the civil court, it would have been a period of a week or maybe slightly more than that where I handed down judgments in applications for leave to appeal. So I understand that that is an incorrect or inaccurate statement about handing down a leave to appeal judgment. That's what is being referred to from what I understand. They haven't complained about my other judgments.
No, they say that this statement is two-pronged. They say your turnaround time for delivery of judgments, they speak of judgments as poor, and then they give this.
I'm sorry, DCJ, can I just have a look at that?
It's in book 1 of 1. Unfortunately,
it's for AFT.
It's not paginated. It's page 3 of the comments under your name.
I've got Professor Matenj was AFT. Sorry, which paragraph?
It's paragraph 6 at page 3 of the comment from the Advocates for Transformation.
Oh, I see. I concentrated on the second part of that because there was no delay in the any leave to appeal judgment. My turnaround time in the High Court, DCJ, is normal. It can be anything between a week and under 3 months in the High Court. So I don't understand where that would come from. If they were referring to Labour Court, where I've addressed that on the last interview, then I would understand. But it's not happened in the High Court.
Okay. Well, there's this other concern they express about how you have handled motion court.
Oh, yes. DCJ, that is surprising to me because I have, this year, I would be in the legal field for 39 years. I've got about 28 years of adjudication experience. I've dealt with complex matters in the CCMA, in the Labour Court, in the High Court. When I came to the High Court, I had no difficulty dealing with the courtroom atmosphere, and I embraced dealing with motion court. I'm not intimidated in any way or any form by the courtroom, the procedures, the counsel who appear before me. So I don't understand how it can be said that I'm overwhelmed. I don't know the paragraph as well, where I recall it says that I don't prepare for motion court well enough, and then I'm overwhelmed by the workload in motion court. That does not happen. When I started to act for the very first time, I was assisted by one of the judges in the High Court who showed me how to deal with the motion court role. She took me through my motion court role, showed me how to work the bench book, all of that. I believe that the 48 hours that we have to prepare for motion court is more than adequate. I am able to go through my files twice over before I walk into motion court. So I don't have a difficulty with motion court at all, whether it's the quality of the work, the quantity of the work, or the people who appear before me, DCJ.
No, thank you very much, Ms. Hiralal. Am I pronouncing your name correctly?
Yes, thank you, DCJ.
I'll hand over to the rest of the commissioners to put their questions to you. And JP Boyotlwati,
thank you.
To whose court you are applying will have first bite.
Thank you, TCJ. Good morning, Ms. Hiralal.
Good morning, JP.
We know each other because when you first started to act, I probably was in the High Court as a puny judge then.
That's true.
Yes. Now, I just want to check in your page 17 of the application form about the acting stints, the last two. Which courts were you in and what were you dealing with there?
My last two acting stints were in Durban.
Yes.
In civil court. I was in both times I was in civil court.
Okay. So just following up on what the DCJ has asked about the comment from AFT. Obviously, I've been the JP since January, but you have not acted where I was the senior judge in the court. So I'm not able to assist this commission about what my gauge was about your performance in the High Court. But I did take that into account and checked with some of the senior judges that were there when you acted. And they seem to support that you did seem overwhelmed at certain times, as particularly in Durban. So I don't know what your view is about that.
Overwhelmed in relation to
the workload, particularly in the motion court.
I'm not sure which judge would have said that. I believe that there was a weekend, the 21st of March weekend, where there was I was dealing with motion court, and it was the start of the long weekend. The Monday was, all cases for the Monday were cancelled. And so I was dealing with motion court, and I had 2 opposed motions on that day, as well as during the course of the morning, I received 2 urgents, which I read during the tea break and prepared myself for. I paced myself well because the representatives for the opposed were already sitting in court early in the morning, and I told them to come back at 2 o'clock, so we'll deal with that. But just before the lunch break, I received another urgent. So in that time, I received 3 urgents. So I may have spoken to a judge about the fact that there's one more urgent, and it's the beginning of the long weekend, and the court staff might be wanting to go away. But then I handled that as well, and ensured with the court staff that if they had to leave by 4 o'clock, at least there would be someone to be recording with those opposed motions that I still had. So that was the position there. But other than that, JP, I don't recall complaining to anybody about workload.
How did you find the workload, particularly in the Durban High Court? Because that's the busiest division.
It is the busiest division. But JP, if I can compare it to the Labour Court, the High Court, and what I have said many times, is that the Labour Court is far busier. And in the Labour Court, I would do anything between 15 and 25 cases per week. That is 2 to 3 reviews, as well as my own motion role. And I handled that. So the Durban court role is not so busy compared to, it is busy, but it's not as busy as it was in the Labour Court. We have time to prepare for our motion court. We're not given trials the day before the motion court. I've not had that experience, but if that happened as well, I would deal with it. I've not had a difficulty, JP.
Yes. Now, the previous interviews I've had regard to that, to the record, and most of the commissioners here and some of the comments refer to the fact that you are better suited in the Labour Court, but you have not accepted that.
That's a good point, JP. I was given the opportunity to act in the High Court first, and I embraced that. I love it. I've worked there with a passion, joy and passion for the work that I've been given the opportunity to do. My last experience with the Labour Court was not so easy, where I picked up 30 reserved charges. I wrote 30. I delivered 30 written judgments in that short period of time. And I understand that that wasn't a good reflection on my performance. And I'd like to compare that to my CCMA performance, where the most complex matters, as a senior commissioner, which I am, the most complex awards are handed down within a 10-day period. No exceptions. If there's an extension, it's only a 7-day extension, which is not much. So the Labour Court, it pained me that I had this blot on my reputation, that I had 30 reserved judgments, and then I had to write these down. By the time I came here at the last interview, I had only 3 left. I don't find that the workload is too high, that it's too much for me to deal with. I've dealt with this kind of work for many, many years, and I would be able to deal with it.
Yes. Now, just going to the booklet that you have submitted, I was overwhelmed by the amount of judgments that you submitted. I didn't know whether you wanted to make the point that you know, because as I recall, you are required to submit 3 or 4. You can choose, but you have submitted more than 4. But that's just a by the way. You don't have to answer that.
Apologies, Chair.
No, that's fine. Now, in the bail appeal that you dealt with, the judgment appears at page 86 and 87, particularly page 87. You were dealing with a bail application on new facts. Well, it starts at page 878, and I'm focusing more on page 87. Paragraph 26 and 27 in particular. You
Yes,
there?
JP?
Yes. Now, you were dealing with a bail appeal on new facts, but you made the conclusion in paragraph 26, but then you went on and dealt with a previous bail application, which in my view was not before you. And you traversed the reasons why you believe the magistrate was incorrect there in having refused the bail application. That's how I understood that judgment. Was that necessary?
I understood that what I was required to do there was to deal with the evidence that was presented by the accused holistically. That is the evidence that was presented at the first bail application and the second bail application, not only the
No, but in paragraph 23, you do say the magistrate found, as recorded earlier, that the facts presented in the renewed bail application were not new facts, and you say you were inclined to agree, and then you state the reasons. And in paragraph 26, you make the conclusion about that bail on new facts, that it was the appellant was correctly not released on bail, but then you go into the previous bail application. That is my concern there.
I will be guided by you, JP.
I think the issue is you dealt with something that was not before you because it was the bail on the new facts that was now before you, not the previous bail.
Thank you for that. I take your point.
Okay. Then on page 61 of your application, you were dealing with that judgment on the stay of prosecution. But I was just interested on what you say about, in page 61,
Yes, JP?
on line, sentence number 2, it appears that the application to strike out was not heard, and there's no explanation as to why it was not dealt with prior to the main application being heard. Was that necessary, that there ought to have been a separate day for hearing the application to strike out, or it could have been dealt with at the same time as the main application?
It could have been dealt with at the same time.
Yes.
The issue here, JP, the issue here was that it was dealt with, and a judgment was issued, handed down, and the applicant in that case did not accept it. It was one of those. It was a unique or peculiar circumstance where the applicant in this case, when the application to stay prosecution came before the first judge, the applicant asked for her recusal because the judgment of the trial court was attached to the founding affidavit. The first judge recused herself, and the matter then came again before the second judge, and he dealt with the application to strike out and issued a judgment refusing the application to strike out, which meant that the impugned judgment stayed on the papers. I was then faced with dealing with the main application, but when I arrived in court, the applicant wanted to deal with the application to strike out again, and raised the point that the impugned judgment is still on the papers, and that if I had regard to the impugned judgment, then I would form a biased view of the case. So I felt that this case could have been handled differently on the basis of the fact that there is this issue where the applicant does not accept the application to strike out. So at that time, it should have been handled separately and then at the main application. But in any event, that's what the result was, that I was then later on required to deal with the main application.
All right. I think I have one or two more questions, CJ, if you may allow me. The judgment, that is the one on Tegeta and others. I'm more concerned on page 168, paragraph 150.
Yes, JP?
Yes, you found that the agency was self-created and that the application should be struck off the roll. But then you went on and discussed the matter further. And the concern, my concern is there is no explanatory note in the judgment as to why you did that.
I'm not sure if can I just have a look at it?
Yes. Paragraph 150 and 151 at page 168.
Sorry, JP, the paragraph again?
150. I find that the agency which the applicants now claim is self-created and the applicants are not without substantial. Did you find it?
Page 150.
No. Page 168 at paragraph 150. Are you there?
Page 168, paragraph
150.
150. My apologies.
Okay, maybe to make it easier for you.
In book one of two,
I've
you
now
have the booklet?
found it at DCJ.
Oh, all right.
Thank you. Paragraph 150. I find that the urgency which the applicants now claim is self-created and the applicants are not without substantial redress in due course.
And you say the matter ought to have been struck off the roll.
It ought to have been struck off the roll, but it appears that the parties then agreed that the matter would be heard on the opposed roll, which is why I then dealt with the matter as an opposed.
But as a judge, what is your duty there? And you've made that decision in paragraph 151. Why you then went on and dealt with the matter?
I take your point, JP.
Yes. So finally, I think, as I said, I am concerned about the concerns raised by AFT because they appear in our courts often and some of the colleagues. And unfortunately, I'm not able to say yes or no because you have not acted under my watch in Durban, all my respect for that matter. So that's where I will leave it. Thank you, DCJ.
Thank you, JP.
Thank you very much, JP. And just a tiny detail in defense of the candidate. A judicial candidate is entitled to list no more than 10, list and supposedly attach no more than 10 judgments in their application form. But I must indicate that I was also overwhelmed by this whole booklet that's dedicated to one candidate. And it's just that your judgments are long.
Yes, thanks.
It was the first judgment, the Optimum Minds judgment, that was very long, DCJ.
Mm-hmm.
My apologies again.
Mm-hmm. All right. Premier?
Thank you very much.
Did you manage to join us? Welcome. Are you well?
Yes, I'm good, ma'am. Good morning.
Good morning. Do you have any questions for the candidate? Premier?
Yes, ma'am. Thank you very much. Good morning. Can you hear me?
Yeah, although your line is not very good.
My line not good.
Yeah, just keep talking. Let's see if you can make out what you're saying.
Okay, thank you very much. My apologies for that. I just want to ask from Ms. Hiralall, what is your view about the independence of the judiciary? Thank you.
Thank you for the question, Commissioner. The independence of the judiciary is most important and integral to the separation of powers and to the rule of law. The judiciary is often called on to deal with disputes that deal with organs of state, and the judiciary is required to be independent. I'll leave it there, Commissioner. Sorry, I have a blank for now.
Okay. DCJ, can I come through again?
Yes, carry on.
Thank you very much. I just want to ask from Ms. Hiralall, you talk about the separation of powers, but what we understand is in relation to those separation of powers, do you believe that it is sometimes another sphere of governance interfering or maybe overreach of other spheres of government, of state, sorry?
Overreach into the judiciary, or the judiciary into the other organs of state?
To the,
Commissioner
overreach into other organs of state. Thank you.
I understand that the judiciary has tried, from the cases that I've read in the media, that the judiciary has stayed out of the other organs of state, and there's been no overreach. Thank you, Commissioner.
Okay, thank you, DCJ. I'm done.
Thank you, Premier. Deputy Minister?
Thanks, Deputy Chief Justice. Just one or two questions, really, Ms. Hiralall. Good morning.
Good morning, Commissioner.
The issue's been raised about the Labour Court, and I think that was from the AFT submission. But I don't know if you've specifically responded to, I don't think it was specifically asked, but why haven't you applied to the Labour Court? Because your expertise does seem to be in labour law. That's the one. And then the other one is just a small question out of interest. Why did you only do a year with ICMEA attorneys for your articles? I see you say you moved to Durban, but Verulam to Durban is not far.
Thank you for the question, Commissioner. Way back in the 1980s, when means were not available and transport was a problem, one had to try and work closer to home, Commissioner. So that's why I had to move from Verulam to Durban. I ran a general practice when I started practice, and then I specialized in labor. I gravitated towards the industrial court because that was the work that was available to me. I had a passion for labor, but at the same time, that was the work that presented itself to me. I developed a passion for adjudication through that, and I've always wanted to be a judge. I did the best that I could at the Labour Court, and then I moved to the CCMA, which was an opportunity that made itself available to me as well. When I was invited to act in the High Court, I embraced that. I was very excited to be coming to the High Court because law, as a lawyer, you want to be able to experience all aspects of the law. And I got that opportunity acting in Pietermaritzburg and Durban. As I said, I did a full spectrum of law in most of the areas of the law. I didn't get an opportunity to act in the Labour Court at that time. And so I continued acting in the High Court, where I did the best I could to develop myself professionally and make myself available for appointment. I did not apply to the Labour Court because my last experience did not give me a good track record or a good performance record. and I did not believe that was going to hold me in good stead. And while I say that, I thought that J.P. Wagley was going to be one of the commissioners here today, because I did explain that when I experienced difficulties with the workload in the Labour Court, I had spoken to him and he understood the difficulties I had there. But after I had acted in the Labour Court, I was not invited to act there again. I was invited to act in the High Court, and so when the positions were advertised, this is the court that I applied to, because I've handed my judgments down here as quickly as possible. I don't see a problem with my track record here. Again, as I say, it pained me that over 28 years or so, it's 10 weeks of work in the Labour Court that caused a blot on my reputation, my work ethic reputation.
Thank you, DCJ.
Thank you, dear. Commissioner Singh.
Thank you very much, DCJ. Good morning, Ms. Hiralall.
Good morning, Commissioner.
DCJ, I don't want to overexploit this issue about the Labour Court and the High Court, but I'm just trying to grasp from my own information. And, if there's anything else you want to tell us, because what we've heard from you, Ms. Hiralall, is that the workload in the Labour Court is something that you found difficult to handle. You are not invited to the Labour Court. Were you aware of vacancies that existed in the Labour Court currently? Because was it yesterday or the day before? Yesterday, I think. No, the day before. We dealt with the interviews for the Labour Court. So I'm just trying to get an understanding of, for me, when I look at your CV, and forgive me saying this, but it's an expression. I mean, you take like a duck to water when it comes to labor issues with hundreds of CCMA arbitrations and things like that. So is there anything else you want to say? I know you've said quite a bit about it to all the commissioners, but is there anything else you want to tell us about why High Court? Thank you.
Thank you for the question, Commissioner. I was aware of the posts that were advertised, and as I indicated, I elected to apply for this post. The reason for that was that I did not come out with a good track record with the Labour Court because I had all those reserved judgments. And I figured that I should concentrate in one place instead of applying in both places. I'm not happy about the fact that I had that number of reserved judgments in the Labour Court. That is something that still pains me. I feel the sting of the blot on my reputation, as I said, of my work ethic. It was a difficult environment, and I watched interviews yesterday where I saw that J.P. Wagley indicated to Judge Moshewane and agreed with him that the Labour Court environment is a tough environment. It's complex matters on a large scale. It's a busy role. The court is under-resourced. J.P. Wagley acknowledged when I spoke to him at that time that they were under-resourced, that I was the only judge. But it did not look good on my CV that I had this number of reserved judgments when I came to the interview. So I still feel the pain of that. I've had to try to live that down on my reputation. I think that's the only way that I can explain it. And I'm happy working in the High Court. I like the variety of the work that it presents to me. It's stimulating, it's challenging, it's exhilarating. The motion court work exposes me to a wide variety of work.
DCJ, just a follow-up, please. Yeah, as I see it, I mean, every court, as far as I'm concerned, is a difficult environment, whether it's a Labour Court, High Court, Supreme Court of Appeal. Now, what assurance can you give this commission that, if you are considered for appointment to the High Court, we won't have this issue of reserved judgments?
Thank you for that question, Commissioner. I've not had a difficulty handing down my judgments in the High Court. I've done them within the time. I can assure the JSC that my track record with the CCMA for 28 years should show that I am committed to work. When I make a promise and a commitment, I deliver. The difficulty that I had at the Labour Court is it's just unfortunate. And if you compare the two environments, the High Court works like a well-oiled machine. You are given your files in time. You have time to prepare, which is why I said that I'm always prepared for motion court. I don't have a difficulty with the workload. I don't have a difficulty with being given a trial or the reviews, appeals, any of those files. They are given to us in time. They are brought to us. We have sufficient time in between to deal with those. The Labour Court environment was being given files the day before to deal with complex CCMA reviews. A review from the CCMA is not a small file. They sometimes come a box per file. And you have to read those entire transcripts in order to write a review judgment. It's almost as if you are sitting in the CCMA dealing with that whole arbitration for 10 days or so, and then writing the judgment in order to find out or determine whether that judgment is, the award is reasonable or not. So it is time consuming, and those files were coming late. If I could share, without embarrassing the Labour Court, but the staff at the Labour Court would confirm this, that apart from being given files late, on the one day I was given a file to read for a review. I read the whole file. I went and sat on the bench, senior counsel on both sides, and started to hear the matter. And then about a few minutes into the matter, I see that the argument that is being presented doesn't make sense to me. And I was shocked. I didn't know how to deal with it. But then I asked, by the way, what is your case number? And I discovered that it was the wrong file. I had read the entire wrong file. And I stood the matter down, senior counsel on both sides. I took an hour or so to read the papers. But the thing that I did, and it's something that we learn at the CCMA, do not postpone, deal with the matter. So I read the papers for an hour and went and dealt with the matter, and then I reserved judgment. But I didn't make the parties go away and incur the cost of having to come back. But that besides, that is the way in which the work is allocated there. So it's not my shortcomings in the Labour Court should in no way impact on the way I handle my High Court work. I love the way the work is allocated there.
I will leave it at that, DCJ. Thank you.
DCJ, may I just comment? Sorry, I just want
Yes,
to confirm.
yes,
I just want to confirm, in fairness to the candidate, that her name has not appeared in the list of reserved judgments that were reserved for more than 3 months.
All right. Thank you, JP.
Thank you, JP.
President Molemelo.
Yes, thank you, DCJ. What I wanted to canvass with the candidate has already been asked by Commissioner Singh, but just one or two things. Your acting period at the Labour Court, you said it was 10 weeks.
Yes, President.
Was it continuous, 10 weeks?
No, it was from July till December. And thank you for this question because it will explain a couple of things as well. I did a pro bono week in July, and I picked up 4 judgments in that week that I had to write. I then acted in the Labour Court for another 2 weeks in August, a further 2 weeks in October, and in the whole of November into part of December until court closed. But in that intervening period, when I wasn't acting in the Labour Court, I was required to go back to the CCMA to complete outstanding part heards. And the call from the CCMA always is that we must deal with our matters expeditiously. We must not have our arbitrations hanging on for a long time because there are employees who are waiting to know what the outcome of their cases are going to be. So I've always had to leave the High Court or the Labour Court and go back to the CCMA to finish up part heards and to deal with matters and hand down those awards within 10 days. And I did an arbitration for the Johannesburg CCMA, which I finalized during August, I think it was, a matter that went on for many, many days. And then I finalized that award during August, September. I also in that time went during the recess to the High Court to complete a criminal trial, and I handed down the judgment there, a judgment and sentence. So in that period from July till December, I worked continuously in the various places that I had committed to work.
But is my understanding correct? Between July and December, there was a time when you actually had 30 outstanding judgments.
I picked up 30 judgments.
Yes.
Yes.
So there was a stage where the total count of your outstanding judgments was 30.
No, Commissioner, thank you for highlighting that. July and August, those judgments were handed down within 2 or 3 weeks at a time.
Okay.
October is when I began to feel the pinch because I was dealing with CCMA award and the High Court judgment that I was dealing with, and the times, it now began to be a slippery slope. November, I was doing 15 to 25 cases per week, and there was no time to read all those files and hand down extemporaries. And that's where the judgments started to pile up. When I submitted my first application in December 2021, I think I listed about 17 to 19 reserved judgments there. Those had accumulated, and that is what I had to work through to try and have ready before I came to the interview here. And while I'm on that, President, I could have finished those judgments long before the interview, because I expressed some concern, and some judges told me, why don't you just do an order and then you can give reasons later on. But like I said, those are not easy cases to just do an order, because later on you come back and you try to reason why you gave the order, and it's going to be difficult if you have changed your mind. So I would rather go through those files properly and hand down a judgment that I'm happy with. In addition to that, what happened was that I had committed to acting in the High Court straight after the December holidays, and I did a crime session in Durban, which was a criminal trial with 21 charges and 64 witnesses. I completed that trial. I was given it on the first day. I completed the trial by the last day of that session, and then I reserved my judgment in that. And then I did a civil court session straight after that. And in that time, I was handing down judgments as best I could in preparation for this interview, so that I could say that I don't have any outstanding judgments. By the time I got here, I still had 3. I could have taken a shortcut and done a wishy-washy job, President, but I just did the best that I could.
Yes, and the 50 weeks that in which you were acting at the High Court, was it continuous or also intermittent?
It was intermittent, or from between 2017 until now. I would do a few sessions or terms per year.
And then go back to the CCMA?
Yes, and go back to the CCMA or to the bargaining councils.
The concern that I have is that at the High Court during those 50 weeks, you at least had time to go back, to get a breather. And in the exchange between you and the JP of that court, you agreed that the Durban High Court is a fairly busy court. And so you would not be getting those many breaks in between. You'd be in court practically every day, presiding over matters and having to give judgments in those matters. I'm a little bit perturbed, and I want you to give us the assurance that if you are appointed, bearing in mind that you will be in court now every day, you'd still be managed to hand down your judgments timelessly.
I'm not sure if I understand the question, President, but are you asking me about the times when I finished a session with the High Court and then went back to the CCMA?
The point I'm making is that because you were not acting continuously, you were not in court every single day. So even in situations where you had reserved judgments, you had time to go and work on those judgments, on preparing those judgments when you were actually not in court. But the difference is that once you are appointed, you'll be in court practically every day. So as you get reserved judgments, you still in court, adjudicating over matters and still have to deliver judgments. You will not, the point is you will not be getting frequent breaks in between to give you time to go and write those judgments. Do you understand the point?
Yes, I understand the question now.
Yes,
Thank
yes.
you, President, and it gives me an opportunity to explain how it is. I would act in the High Court, and then my livelihood comes from the CCMA work and the Bargaining Council. My acting in the High Court is a sacrifice which I make for my professional development and for the commitment and the fact that I want to be appointed as a judge for the contribution which I can make to the judiciary. But apart from that, I have to earn a livelihood, and my livelihood comes from the CCMA. When I finish in the High Court, and if I've got a few reserved judgments, at the same time that I'm working in the CCMA, when I've left, I've got to hand down awards, and the time limit, the deadlines there are 10 days to hand down those awards. So if I've left the High Court, say at the end of March, I'm immediately back in the CCMA, and I've got to deal with my cases as well as some long-standing part herds, which, because I'm a senior commissioner, I get those very complex ones that take some time to finalize. So I've got to pay attention to those. And when the awards come, those are very complex awards. It's like a large, long civil trial. It's time-consuming. It has to be done within a 10-day period. So sometimes the award has to take preference. But those judgments still, President, they are handed down within the 90-day period.
But this explanation you've just given, I'm sorry, President Nirmala, this explanation you've just given perturbs me highly, Ms. Hiralal. If, as you say, you earn your living in the CCMA and you have to give the matters you deal with the priority, we all respect that. Now, what I don't understand is why you would accept an acting appointment either in the Labour Court or in the High Court, knowing that you have parted matters that require, an expedited disposition.
Thank you for that question, DCJ. My JP would know that when I acted in the High Court for the first time in 2017, I loved the work there and I really wanted to come back. However, for 2 years, I declined invitations to come to act in the High Court. That was from 2017 till 2019. If you look at my application, it shows the gap. I had several calls from the previous DJP, Madondo, as well as my current JP, to come and act in the High Court. And I would have to decline because of my commitment to social justice. And there came a time where I said, okay, I'd like to I need to do some of the High Court work because I want to apply at some point. And I spoke to the senior in KZN, and he gave me some time off. But at the same time, where you have these some long-standing arbitrations in the CCMA, they are, and they probably watching this interview because I have their full support. I would make time available after the High Court where they would be calling for dates to come and deal with the matter. And I go there and the matter's scheduled for 5 days and the parties have removed the matter from the roll. So it's a two-way street. I also had to deal with my professional development, but as I said, DCJ, I've not at all dropped the ball as far as social justice is concerned and dealing with CCMA matters expeditiously. I've made sacrifices for that.
My concern is that what you describe as a sacrifice for the benefit of the judiciary actually benefited you and not the judiciary, because my understanding of your explanation is that, well, it's what you said, you left the Labour Court with a long string of reserved judgments and went back to the CCMA. And when you got to the CCMA, you did not have time to catch up with the pending, the reserve judgments, because you had to prioritize the awards that were some which had been long outstanding in the CCMA. So the matters that had been heard in the Labour Court had to wallow for a while you served the place where you earn your bread, as you describe it.
It may appear so, DCJ, but we had also come out of COVID at that time, the COVID period, the pandemic, and there were a number of part-herds that were waiting to be dealt with. And that is when I dealt with, in August, September, with an arbitration that had been waiting during the COVID period. And that was a Johannesburg matter where the parties were not always available. When they requested a date, I have email correspondence. When they requested a date, I made myself available immediately.
Look, we've spent quite an inordinate amount of time on this aspect, but before we leave it, I just want to get an assurance from you that you understand that leaving the Labour Court with the reserve judgments, which you could not finalize in time because you had to prioritize the work at the CCMA where you returned after your acting stint there, actually prejudiced the Labour Court, because those judgments remained outstanding for an unduly long period of time, and those litigants suffered while they were waiting to hear from you. You don't seem to want to acknowledge that there's a problem there.
I take your point, DCJ. I understand what you're saying.
All right. Sorry, Press, had you finished? Okay. Professor Marumachai?
Thank you very much, DCJ. Good morning, Judge. Good morning.
Good morning, Commissioner.
Should you be successful, you will be sitting in motion courts. And sometimes you find that, and of course, I mean, with courts which have not yet went digital, as it were, you find that some affidavits will be put into court files without even the necessary authority. After the 3 accepted affidavits having been filed, like your founding affidavit, your supplementary affidavit, and your replying affidavit. And you'll find that sometimes parties will put in supplementary affidavits or even further affidavits. In those circumstances, when you are hearing the arguments and you find such an affidavit in the file, for you to accept such an affidavit, what should the party who filed such an affidavit have to satisfy you with for you to accept that affidavit?
Thank you for the question, Commissioner. The rule is three sets. A full set of papers is 3 affidavits. There shouldn't be an extra affidavit in the file, and certainly not without an application for leave to file such an affidavit. When such an affidavit is filed, it upsets the evaluation of the evidence based on those 3 affidavits that are allowed. I would deal with it either by disallowing the filing of the further affidavit.
Sorry, just to assist you, what I'm actually looking for is, yes, you need to make a decision at the end of the day. What should the party who brought in that affidavit have to satisfy you with for them to at least stand a chance of being successful in you accepting that affidavit? I'm just trying to see what do they have to do. Yes, they will have to apply for your indulgence, but in applying for your indulgence, what do they have to satisfy you with for you to consider that affidavit?
They have to show that the evidence in that additional affidavit is relevant and necessary, and it will be in the interest of justice to allow that further affidavit, and that it's not going to prejudice the respondent. Although the respondent will be given an opportunity to answer, but that is not going to prejudice the respondent.
Okay, thank you very much. Thank you very much.
Thank you, Commissioner.
Thank you, Commissioner Marumachai.
Sorry, can I just add to that?
Yes.
My apologies. And that it's not something new that should have appeared in the founding affidavit in the first place. Thank you, Commissioner.
Thank you, DCJ. Good morning, Ms. Hiralal.
Good morning,
Is it
Commissioner.
Hiralal, ne?
Hiralal.
Hiralal. Oh, I got it first time right. Just as a matter of interest, did you use the researchers that are available in the Labour Court when you picked up those reserve judgments?
JP, Commissioner, I did ask Mr. Vilakazi about the researchers, and he told me that they were not available. There's no researchers. I believe I might even have an email, because I'm used to using the researchers in the High Court, and I thought that that was something that was going to help me, but I was not given that facility. Also, if I may point out that I understand that there is a briefing session a briefing with the JP before each session that you act. Judge President Wagley apologized to me on the telephone for twice, for leaving me out of the list on the email for such a meeting where I would have been briefed as to what happens in the Labour Court.
Okay. One last question, DCJ. Well, 1.5.
Go ahead.
The one question is, it's a follow-up. You say you prepared on the wrong file and only realized it was the wrong file when council were addressing you. But didn't you get a roll or a roster when you were appointed, which tells you what matters you're appearing in?
No.
What do you mean, no?
No, Commissioner. I wasn't given a role. That is why I say that the court was handled, compared to the High Court, it was not handled in the right way. I was given files like the day before. I didn't have a copy of the roll in time. I got a copy of the roll maybe later on in the week, but not at the beginning. I would be told, okay, these are your 2 files, and I didn't understand how the roll worked in the Labour Court.
Let me understand this. I'm sorry if I'm belaboring it. You were not appointed on the Friday for the next Monday. You were appointed there was quite some time before you started, isn't it?
Yes, JP.
But what did you receive?
I would not receive my files as early as I had requested, and I do have emails to show, which I'd written to Mr. Vilakazi saying, I require files to read, and he would not have them ready. So I'd either go to the Labour Court to collect them on a Friday afternoon when they're ready, or on a Monday for the Tuesday, because Monday would be the reading day.
Okay, no problem. The half question, DJ, is, have you attended judgment writing courses?
I've attended surgery training, but not judgment writing specifically, and I do believe that I can benefit from a course of that kind if I am appointed.
I see. Because I looked at one of your judgments here where you simply go into the merits, and way down the judgment, I'm still battling to find out what's the matter about, what you're deciding.
Which one is that, JP?
Okay, let me show it to you now. It's the matter that involved Brian Edward Caniff. You've attached it. It's page 94. Yeah, Brian Edward Caniff and Mbusisa Comfort Ngogo and others. You see that matter?
94. Yes, I do, JP.
Yeah. So I see there's an order at the beginning of the judgment. And then when I go to, you say introduction, then you tell us about Brian, who the parties are, and then you go into the factual background. I went up to page 11. I still don't know what is this matter about. I don't know where you tell the reader of this judgment what you're deciding here.
Find the issues at paragraph 31, issues to be decided.
Which is well into the judgment. I think that's the point, because that's what I see in another judgment as well, that you then say what is to be decided here, well into the judgment. That's why I'm asking whether you've attended any judgment writing courses.
No, I haven't,
Yeah.
JP. And thank you for pointing that out. I will keep that in mind.
Thank you. I think the JP has heard you. Next time there's such a judgment writing courses, hopefully she'll include you.
Indeed, JP, my JP Poyo Ilwati made it possible for me to attend the SAJE training in
Yes.
January this year.
Yes. My comment, DCJ, I think as a head of court, I think you are better placed in the labor court. That's where your expertise is. That's your daily bread. I think you should go back to that court and rehabilitate yourself. Thank you, DCJ.
Thank you, JP.
Thank you, Commissioner.
Commissioner Bernard?
Thank you, DCJ. Ms. Hiralal, just what is apparent from the range of cases that you've added is there's you grapple with some important procedural and constitutional issues, and they varying. So your range of experience has been good in the KZN division. Now about something like the Tracker K or Tracker Connect matter versus BE Women Training, where you grappled with the discharge of an until order or whether to confirm it. And then on the other hand, again, in the Nick Garner matter is the application for stay of prosecution. So just to, on those matters, I mean, there were some important constitutional considerations also in your mind when you dealt with it. One can see that from the cost order and so on. So maybe you want to address the Commission just on your exposure to various types of matters, particularly these two and the constitutional issues involved.
Thank you for the question, Commissioner. Good morning. Yes, when you highlight those two judgments, I appreciate that I could have commented more as far as the access to justice issue in the stay of prosecution matter was concerned. And the other one is Tracker Connect, the invasion of privacy and the balance of power between the applicant and the respondent in that Anton Pillar award judgment. I appreciate what I take your point on that. I should have commented more. I have done other judgments where I've had to deal with the issue of pacta sunt servanda and whether it is applicable in a contract judgment, and I found that I had to balance the defense that the respondent presented together with pacta sunt servanda, and I dealt with it there, but I should have commented more in these judgments on constitutional issues. When I was preparing for this interview, I did a lot more reading, and I realized that, and looked at those judgments, and I acknowledged that I could have done better.
Yeah, I'm not being critical. I'm just saying, in your mind, it's just to bring that to the Commission as well.
Certainly, they were very much in my mind. Like I said in the Anton Pillar order, it was very much in my mind, the balance of power between the two parties, but I should have commented on that as well. Thank you, Commissioner.
Thank you, Ms. Hiralal. Thank you, DCJ.
Thanks, Commissioner Bernard. Any further questions from the virtual platform? No.
No, thank you, Deputy Chief Justice.
All right.
No question, Deputy Chief Justice.
Is that Commissioner Posoli Rutori?
Yes, Deputy Chief Justice.
Or how are you feeling today?
No, I'm feeling much better, thank you.
Oh, that's a relief. Ms. Hiralal, we've reached the end of your interview. Thank you for making yourself available for the vacancy. You're excused.
Thank you for the opportunity, DCJ. Thank you, Commissioners.